Okay, thank you and welcome everyone to our ACA reporting seminar. My name is Bob Sang. I'm a partner, I'm a boomerang lawyer, partner in the employee benefits group at Dorsey and Whitney. I started my law life here what feels like a long, long time ago, and then did a 13-year stint as assistant general counsel for pay and benefits at a little company by the name of Target in town here, and have been back with my peeps for the last couple months here, and am thrilled to be here. Although I'll tell you, I'm working harder than I have in quite some time. I thought the pace was fast at Target. ACA is really keeping us busy in a good way. It pays for college tuition. Okay, big crowd today, and we do have some overflow space. I think of them as the crying rooms that I don't know if we're using or not, but if there are some of you in the crying rooms, welcome, and we're sorry we have kind of hit tilt on space here. We have almost equivalent number of people calling in or logging in via the web for a webinar version of this seminar. That gang, welcome to all of you. You will be seeing our slides, not our faces. And we debated whether to do this as two separate presentations, and kind of landed on it's not bad to have the kind of the film before a live studio audience thing, because it puts a little more energy into the webinar. And those of you who are doing this via webinar, we welcome your input on that point so we can kind of plan for future events. This may well not be the last ACA reporting seminar workshop that we have before the end of the year. And one more welcome to Alliance Benefit clients. You'll hear a little more about Brad Aarons and Alliance Benefits, but we are happy to have a number of those employers here in person and on the webinar. Let's see, just a couple tidbits. We are talking today about the first ever, I'm told, landscape tax reporting form in the history of the IRS. You know, these 1094s and 1095s are shaped like this because they have so much information. This is kind of big deal stuff in a narrow way. And let's see. Okay, we'll do some more technical details later, but I'd like to begin by welcoming our panelists, and I'm going to ask them to introduce themselves relatively briefly, but long enough so the webinar people get a sense of voices and names. And we're going to start with Brad and move down in the direction of Linda. Take it away, Brad.
Thank you, Bob. I am humbled to be on this panel, and I will say from the start that all the heavy lifting is going to be done by the rest of my counterparts on this panel. I work for a vendor, Alliance Benefit Group, who's a consulting firm that works in the employee benefits space. And so the color commentary that I will be able to give to you is basically some tips on how you should do this. We have a division that actually helps employers with ACA reporting, and so I can kind of give you some guiding principles or some tips on where to go if you want to outsource this. But I'd like to thank Dorsey for putting this on. I'd like to think that some of that had to do with me kind of pushing them to do this, just because I detected that many of my clients and then people who would call us really didn't understand that their job was not completed once they determined that they had a compliant health plan under the ACA. There was actually more to it than that actually takes effect this year. And I know that I probably have some clients listening in that perhaps haven't or aren't as far along as they actually should be in the reporting side. So I'm very grateful that Dorsey is putting this on. Good. And thank you very much, Bob.
Thank you. Stacy.
Hi, everyone. I'm Stacy Rice. I am currently in-house at Cargill in the law department. I handle the qualified retirement plans and the health and welfare plans. I do the qualified side of things, and then we have another lawyer in the department that handles executive comp and deferred comp and stock plans. So my world is focused on the qualified side of things and a lot of time, obviously, currently on the health and welfare side of things. I practiced at Great Plant Moody for several years before coming to Cargill. I've been at Cargill about 5 years now. And I'm here to offer the large employer perspective, some issues we're seeing and how we've worked through various of those issues. Hopefully add some value in that way.
Good. Thanks, Stacy.
Hi, I'm Liz Steckman. I am an attorney here at Dorsey, but actually I'm an attorney in the Seattle office. I'm originally from Milwaukee, Wisconsin, so I'm glad to be back home in the heartland. I do a lot of work with employee benefit plans, pension plans, 401k plans, and also health and welfare plans. And this area is probably the most challenging part of the practice area right now in terms of 2015. So I'm glad you're all here to find out about reporting.
All right, Holly.
Good afternoon, everybody. My name is Holly Fissler. I'm an associate here in the benefits and compensation practice. I spend half of my time on qualified retirement plans and the other half on health and welfare. Have been enjoying the Affordable Care Act in all of its incarnations since day one, and I still get that, kind of giddy feeling every time there's been new guidance issued. And it's just, it's always fun to see that come across the desk and say, ooh, what now?
Thanks,
ahead,
Holly.
Melinda.
Thanks. I'm Melinda Mayer, and I'm a partner in the benefits and compensation area. I'm a boomerang lawyer here as well, and wherever I go, Bob follows, hopefully. Or at least he's followed me back here. I started my career here over 20 years ago in the litigation department, and have since left a couple of times to work for healthcare companies, eventually finding my way back home. And so I'm thrilled to be here, and I am so grateful to have these panelists and have Bob here working with me now. Thanks.
And I should say Melinda was away last week, so that means that we assigned lines 14, 15, 16 to Melinda in the most junior, but probably most informed person on this team, Holly.
That's right.
Okay.
Thanks, Bob.
You're
Appreciate it.
welcome. Okay, couple more details before we get started, and then we'll dig in. We are I always get nervous when I say this. We're in the 21st century, right? Not the 20th? Okay, 21st century. And we will be live tweeting this seminar. Jeff Bauer, Mr. ESOP extraordinaire and other things, partner in our department, along with his able assistant, Tim Goodman, a partner in our department, who is expert at ACA reporting as well, are going to be sort of trying to summarize some of the gems that pop up during our conversation and tweet them using the hashtag DorseyACA, okay? One word, DorseyACA, and would encourage anyone on the webinar or live here to join in on that one as well. Let's see. What other technical details? Questions. We want this not to turn into a circus, but we want this to be interactive, okay? That means we're going to take some questions, and there are a few ways, multiple channels, we used to say at Target, for submitting questions, okay? One would be simply to tweet a question, and we'll be monitoring the feed. Another would be to send an email to nickerson.debbie@dorsey.com. Debbie is an admin in our group, and she's monitoring her emails as they come in, okay? And both the tweets we'll kind of watch on the screen, emails will come in to Melinda, and then last but not least, we're open to questions from the live audience here. Crying room people, if you want to come in and raise your hand, we'll do that too, and we'll answer the question. Use your judgment in terms of if it's real specific, maybe save it for later and ask us. If it's something that has a little more general application, that's better. And if we don't call on you, don't jump up and down and wave your hand. It might mean that we just need to keep moving along. Okay? Sound good? Panelists, anything to add before we start? I have one more thing to add, and that is New York people. I'm supposed to do this twice. The CLE code is XQK821. And don't tweet that, Jeff, because apparently we're not supposed to do that. XQK821 is the New York CLE code. All right, Here we go. ACA reporting. This is going to be fun, multitasking here. A couple updates before we do ACA reporting. Now, I don't know, you've all been away summering for the weekend and probably answering Monday morning emails, so you probably haven't seen that we've got more ACA rules delayed. Anyone see that? Okay. That's the good news. We've got ACA rules delayed, but it has to do with the calorie counting disclosure requirements, not ACA reporting. So the question that everyone is asking these days is, are we going to get any relief on ACA reporting? There are a few bills that have been introduced in Congress. One by Senators Portman and Cardin, respected Republican, respected Democrat, that would change dramatically the ACA reporting rules. Another one by a House member, House members Black Thompson. The thought is, I had some long conversations with the staffers for Warner and Portman a couple weeks ago, and the thought is this stuff is incredibly toxic, any legislation having to do with ACA, so they are going to try to sort of lay low as they introduce these bills. And the bills would have no relief for 2015 at all. And they would contain no instructions to the IRS to stand down for 2015, because that would be sort of like a lightning rod on the legislation. The hope from both of those staffers that I talked to was, if this stuff gets launched on the floor and if it doesn't get sort of ridiculed as a sham and draw more lawsuits, there's a possibility that right before the legislation is adopted, there would be a friendly amendment that would be tacked on to one of those pieces of legislation that would instruct the IRS from Congress to stand down for 2015. And that would probably come in the form of some delays in the reporting dates, but probably not make this go away. So we may see some developments legislatively or administratively with respect to ACA reporting, but don't get your hopes up for a lot to happen. Let's see, King v. Burwell kind of seems like yesterday's news now, but you know, that was the last Supreme Court case that had potential to really upset the apple cart. Justice Roberts, writing for the court, kind of put that nail in the coffin, and with King v. Burwell out of the way, it's all systems go. Okay, that's the quick update. Now, and I should just look at the panel. Anyone want to add anything by way of updates? Okay. Pieces of ACA. So we're going to, this approach, the seminar approach that we're taking today is, our attempt is to sort of build the structure, the framework for ACA reporting. We're going to miss some of the details that you're going to see in some of the seminars. And part of what we want to do, my hypothesis is that it's tough to answer those questions about how to describe a divorced COBRA participant coverage with an adopted child on lines 14, 15, and 16 of 1095C unless you have a little sense of the big picture, okay? And a lot of you in this room aren't going to be filling out those 1095Cs. You're going to be advising your vendors or perhaps your payroll department on how this should work. And my opinion is that you can't do that if you don't have a sense of sort of the big picture of ACA reporting and what's going on. So our goal, we will have succeeded today if you walk away with sort of an outline in your head of the big picture of the 1094, the 1095, and some of the labels that are necessary to complete those forms. I think in outlines drives a lot of people crazy. Okay, so the three, Roman numerals 1, 2, and 3 for our outline here really would be the pieces of ACA that are especially relevant for forms 1094 and 1095, okay? The first one would be the employer shared responsibility provisions. I refer to it as the employer mandate. This is the piece of ACA that says employers shall offer coverage to a certain percentage of a certain type of employee, and if they do, they don't pay a penalty or a tax, whatever you want to call it. So employer mandate, And then the individual shared responsibility rules, in other words, the individual mandate, that rule that says, I gotta go get, I have to go buy insurance, okay? And then the last piece would be the subsidies and the premium tax credit. This is the government assistance to certain individuals to buy the insurance that they've been told they have to buy, okay? Those are the three pieces of ACA that come into play when we're talking about employer reporting, okay? All right. Agenda. We have an agenda for today, okay? Three chunks here for this workshop. First would be administration and workflow for ACA reporting. And would love a little chitter chatter either on Twitter or live if people have some best practices or some stories of mistakes that they've already encountered in putting together their workflows internally to make ACA reporting happen. Second would be our Form 1094C. That's the cover sheet, okay? Here is the 1094C that every employer will have to file with the IRS. Webinar people, I'm just holding up a copy of the 1094C on my clipboard, okay? Now I'm going to set it on a pile of copier paper boxes, a big pile, and these, you'll never know. They might just be blank pieces of paper, or they might be completed 1095Cs, because at Dorsey, I think Susan Revere is here, we're way ahead of things, okay? Okay, so there are the chunks of the seminar for today. Administration and workflow, 1094C, the cover sheet, 1095C, the individual forms, okay? Some of you might be saying, well, what about the 1095B and the 1094B? We are not going to get into much, if any, detail for the B series forms, okay? They have some play for large employers, especially with insured plans, but we won't be spending much time on the Bs. A lot of the concepts will help you through the Bs as well, okay? Did I see someone moving their head that wanted to talk? No? Okay. All right, let's see what's next here. Administration and workflow. Okay, so, you know, I get the sense, Brad, Aarons, and I had a little conversation earlier, and I actually, in the last few days, have had lengthy conversations with the lead ACA reporting project people for two of the very, very large national vendors. And I promised them I wouldn't tag them with the names of their institutions because these were sort of informal conversations. But the conversation that I had with this gang, these two people in the large groups, was my sort of hypothesis is that the smaller, meaning like maybe under 500 life plans, are closer to the action on ACA reporting, and they have a pretty good sense of some of the challenges and the workflows, in part because fewer of them are outsourcing this stuff. They're having to do it themselves. I did a talk to a group of insurance brokers and some of their clients recently, and they had information on ACA reporting that made my head spin. Whereas I know some of my friends in the larger corporations are kind of saying, you know, we got ADP hired, we got Equifax hired. This ACA reporting is not that big of a deal. And I have the sense that in the larger companies, there's the chance that no one is really in charge of this thing, and that there are some surprises that will be happening. Brad, you had a little different perspective on this.
Yes, in fact, it was just the opposite. I had a perspective that a lot of small to mid-sized employers felt that their job under the Affordable Care Act was basically taken care of once they determined that they offered a health plan that complied. So I hope that is, that you're right, Bob. But I sense that that even though some may be aware of their reporting duties, that it's being put off,
Okay.
so to speak, and I worry about that. I do.
Yeah.
I worry a lot about that. Out of all of our clients, I can tell you only one of them hired a person specifically to deal with the Affordable Care Act, and that was a school district. I mean, they hired a person. just to take care of that. I can't say she was an expert at it, but nobody was. But that is her job, is to be responsible for the Affordable Care Act at that school district. I think most small to mid-sized employers who are basically our clients are either going to do it themselves or they're going to outsource it.
Stacy, what's your take on the large employer side?
Well, there were definitely some discussions internally when this first kind of hit, when we realized we were going to be doing it for 2015, as to where this, did it lie in tax, did it lie in payroll, did it lie in benefits? And I think ultimately, since it's more akin to a W-2 type form, it landed in the payroll area. But at the same time, I think we were pretty aware that this was not something we were going to be able to do internally. And so I think there was, I felt pretty good about how our benefits group realized how much of a big deal it was. And they did hire the vendor, and I think we do have someone that's dedicated to pulling together the data that's needed to get to the vendor, because I think that's the key issue, is just because you have the vendor doesn't mean you have the data ready to get to the vendor. And so fortunately, we have someone that's spending quite a bit of time pulling that data and then getting it in the format that the vendor needs it. And then kind of odd questions that I'm starting to get are, so we have domestic partner coverage. Do you send them over as a spouse or a dependent? And things like that I think are, once you start actually implementing the forms, are going to start to come out.
Yeah, the
those
word
kind
I
of
got
questions.
from one of these large vendors was that payroll seems to be it in a lot of big companies, but what they have found, especially in the last even couple weeks, was that payroll speaks a different language than benefits.
Yeah, I mean, the benefits group is the group at our company that's feeding the data to the vendor.
Okay.
I'd say at this point, payroll's not all that involved.
So, classic problem that I've had probably a half a dozen times in my career has been, this isn't always healthcare. Sometimes it's life, disability. Pick a life insurance example. Employee drops dead in the middle of the workday and doesn't have life insurance. And spouse says employee had life insurance. And we're scrambling to figure out how we know if employee was ever offered life insurance. And we're finding that questions as basic as that, I hear from the the ACA reporting vendors whose names will go unmentioned, who you'd probably figure out if you thought about it, was that something as basic as determining how to show that an offer of coverage has been made is harder than they expected. Okay, Brad.
Yeah, just a quick comment, Bobby, because I think there needs to be a distinction made between payroll and the HRIS system.
Yes, thank you.
The HRIS system for many employers is actually provided by your payroll vendor. And actually, the data you need, more than likely, is going to be on the HRIS system. So whoever is in charge of that system holds the keys to success here, even though it might be coming via your payroll vendor.
I see that we've had some questions coming in. Do we want to touch any of them before we move on, Melinda?
Not yet, Bob.
Okay.
Still working on it.
Okay. I have seen, just sort of raise your hand or something if you have one. I was gonna hand out white flags and let everyone kind of hold up a white flag that says I surrender. But it's an idea that won't happen. Okay, I saw one person who I'm not sure if he's in this room or not, put together a sort of a worksheet with all of the lines on the 1095 and 1094C, and then sort of a series of columns after those lines describing where the data was coming from. I would encourage, we should have stolen that and put it in our deck, but I'd encourage any or all of you to put something like that together and use it as a way to sort of test how you're doing, if you know where things are coming from. Okay? Do we want to talk about BAAs, Melinda? I think we're going to, just for a second, all right? So the question that we don't have an answer for, solid, is whether the employer wants a BAA with the ACA reporting vendor.
And for those of you who may wonder what a BAA is.
Oh, sorry.
It's a business associate agreement under the HIPAA privacy rules. So I'd say two things. One thing I want to say is what we're finding, I think, is the big vendors are fairly rigid right now. So if you sign up with them, you get what you get, no matter how big you are. It's surprisingly, what I find is even if you're a very big employer that is used to having the vendor customize their processes, you won't get it, or at least I haven't seen that yet. And that's a shock, and the later we get in the year, of course, the worse that will get. In fact, what I'm finding is some of the vendors won't take you after a certain point, which is a little scary. So have that in mind. Now, the second thing is, with respect to the business associate agreements, some of them are saying, look, we are not your HIPAA business associate because we are not getting PHI. What we are getting is enrollment data. That's a question, I think that's an open question, and really has to be analyzed based on where the data is coming from. From your perspective, if you're an employer, you are much better off getting a business associate agreement. So we have seen a little flexibility on that from the employers. They'll say, well, if we are a business associate, we'll agree to do these things. Not necessarily that they would concede that they are a business associate. So that might be an approach you can take. But, I think our advice overall would be get a business associate agreement if you can. If they won't give it to you, you have to analyze that pretty closely.
Yeah, and hopefully this is obvious to all of you, but even, set aside the question of whether you want to be a business associate addendum or not, agreement. We are sending some massively sensitive information to these vendors. And I'm sure all or most of you have sort of standards in place to run those vendors through their various checks to make sure that they're secure. But, if that's something you want on your checklist.
I think that's an excellent point. Think about it. The socials, not just on your employees, but for all of their dependents. That's scary. That's scary data. So you want to know that they've got the right protections, and you want protection in your contract for that, even if you don't get a business associate agreement. In fact, I would say to you, don't just rely on the business associate agreement, because that's got what HIPAA wants you to have, but you want a whole bunch of other data security protections in your contract with these vendors.
And I can't wait to do some work for a client who's fighting with the government on this, and when there's been I'm sort of being funny, and there's been a breach, and we can say something like, well, we're more careful with our data than you guys are with yours. But hopefully we don't have to make
This
that.
coming from a guy that worked at Target.
So just a quick, if anyone has a really thorny, complicated 1095C line 14, 15, 16 question, mayor.melinda@dorsey.com. Okay. There's probably time for one or two comments if anyone has any best practices ideas for workflow on this stuff. Anyone care to venture into the breach here? Yeah, it's gonna be. I had a law professor who used to say that learning the law is like eating sawdust with no butter. We are just raining sawdust on you guys today with no butter. If you're quiet, I can certainly appreciate that. But don't hesitate if you have ideas to help us out here. Okay, we are moving from workflow, but please go back to your desk and even before you think about 1094 and 1095, think about your workflow, okay? Because if something melts down, you know how fingers can point, and the benefits people will certainly be a place to point fingers to. Hopefully not the lawyers. Okay. All right, so we have, we're going to start, Liz and I largely are going to start with a walkthrough of Form 1094C. Again, that's the cover sheet that gets used to transmit the 1095s to the IRS, okay? And if or when I screw up my references to these forms, someone sort of raise their hand or correct me, because I actually have in my office one posted on the wall that says 1094C, a big post-it, and then I've got like about a dozen little 1090 post-its underneath it that have 1095C on them. And that's my sort of memory aid when I'm talking on the phone so I don't get these things mixed up too much. Okay? The 1094C demonstrates compliance with the employer mandate, okay? So this is how the IRS is going to be checking on employers to see if they've complied with 4980H, A, and B, the employer mandate. It serves as a transmittal form, cover sheet for the forms 1095C. And it also contains a list of aggregated control group employers in your control group, okay? And we're going to spend much of our time around 1094C talking about these. There's 3 employer labels that all spring from a good understanding of your control group. We'll be talking about that relatively soon, okay? But before that, just a little compare and contrast foreshadowing to kind of refresh everyone's memory in terms of what a 1095C is. I think of the 1095C as a little like a Form W-2. It goes to employees, individual employees. It tells them what kind of offers of insurance have been made to them. 1095C, in terms of the numbers that go to employees and the different types that go to employees, gets fairly complicated. An employer, let's see if I can say this right, and Liz or Melinda or Holly in particular correct me, because we spent, I think, 20 minutes on this sentence, which is sort of inartfully written. An employer subject to ACA will issue several Forms 1095C to certain individuals. I can correct myself, or I can ask one of the panelists to refine that statement just a little bit.
Yeah, I'm sorry, Bob, can you change the slide? Are you on the next slide
I'm
now?
sorry.
That's okay.
There we go. There's the slide.
So yeah, so Bob's talking about the second bullet, and we're on the slide that starts with foreshadowing 1095C. We're talking about the second bullet. This did engender a little conversation. So in my mind, it's slightly misleading. I think an employer will issue one 1095C for each of its employees. So each full-time employee and each employee to whom you offer coverage will get a 1095C. So you won't have several 1095Cs. You will have one for each employer. Now, several employers within a control group may issue separate 1095Cs to an individual, but one employer with one EIN should have one 1095C. So that's what I would say about that.
Good, thanks. You can get in the weeds pretty quickly when you start thinking of the different combinations of 1095 Cs and Bs that might go to individuals. And I think there's going to be a lot of confusion. I see Sue nodding her head. There's going to be a lot of confusion among individuals when their mailbox fills up with these things, and they're going to try to figure out what the hell they need to do. Okay, the 1095C, because it shows in some cases that someone has accepted an offer of coverage, it shows their compliance with the individual mandate. And it has information that goes to the IRS on the type of coverage that may affect subsidy eligibility. Okay? So the point that I'm trying to make here is that it's good to think about, especially this group, it's good to think about the purpose for these forms, because that will guide how you answer some of these tricky questions when you get down into the weeds. Okay? And I will tell you that no one has what is the owner of the truth on how you fill out these forms. There are, once you get into the codes and things, there's so much gray. The importance here is that you think through your response, and then that you become consistent with your response. And I think also developing a little bit of a trail of the advice that you've given to your vendors and your colleagues around what things to do will be handy, okay? Now, there's going to be some, I mean, there's a lot of confusion here. There's going to be some creative writing in these forms. But remember, you're signing these things under the penalty of perjury, okay? So best efforts are important. So I'm kind of giving you two pieces. No one's going to get this totally right, but you got to try, okay? Let's see. Just one other aside that I meant to mention a few minutes ago when we were talking about the large ACA reporting vendors. This is just sort of like manna from heaven to lawyers, and I'm not making this up. But the person at this vendor said, I said, okay, we are getting just wailed on with responses or with requests for information, and you're asking us for more information than you need to complete these forms. What's the deal? Their response was, this isn't just an ACA reporting platform that we're building. This is an ACA compliance platform that we're building. So, you know, Melinda and I have been talking about this, and Holly a little bit. You know, what you're seeing in these data requests is sort of the starting point for ACA administration. One of the people I talked to said that the larger TPAs, the Aon Hewitts and Tars Watsons and the like, kind of thought that they would be ACA compliance. And it's starting to look, it'll take some time for this to shake out, it's starting to look like it may come from these reporting vendors. Okay? Now, this is the part that's fun for the lawyers. I said, okay, if I've got someone who just can't give you all the junk that you want on these forms, and they call you, and I've got some big employers that have called you, and they get sort of treated like they're dialing into a 1-800 number, which they are, how do they get past the logjam? And this person's response was, everyone write this down, if the client has a lawyer on the phone, then we put one of our lawyers on the phone and we talk about how we might be able to skinny down the data request. So there's not a lot of room to budge in responding to these data requests, but you don't need a lawyer, but push it a little bit. If there's information you just can't give, and you will have to be kind of the squeaky wheel to get escalated beyond probably your account representative, because the word that the people in charge in these organizations is giving is only budge if you really, really have to. Okay? Okay. So we did the compare and contrast already. Webinar people, the slide now shows the 1094C on a nice table all by itself and the boxes of 1095Cs. That's just sort of the memory device to keep these things straight. Okay. So remember, we're on 1094C. And if you look, I think you all have 1094C. Take a peek at it in your handouts. You're going to see a lot of lines that ask for information from. They ask for information from the applicable large employer member. They ask for, let's see. They ask if it's a member of an aggregated ALE group. They ask for a listing of the members on the schedule. So these are terms that you have to know to be able to communicate with the people that are running the show. And you can't get into these ACA-specific terms, ALE and various words added onto ALE, unless you know what your controlled group is. All right? So I am going to hand this off to my Seattle partner, Liz Deckman, to start the kind of the toe in the water into what control groups are, which will lead to the better sense of the ALE terminology. Take it away, Liz.
Great, thank you.
And Liz, remind me when to flip slides, or tell me, okay?
I'm telling you now, please, please flip to, that's perfect.
How's that?
Great, thank you. So what I'm going to be talking to you about today are controlled groups. And controlled groups come in lots of different varieties, but I'm going to talk to you about the three kinds that we see most often. And the first one is a parent subsidiary control group. And that is, for example, a corporation who owns a subsidiary. And as long as the parent corporation owns 80% or more of that subsidiary, they're in what's called a parent subsidiary controlled group. That's pretty easy. If the subsidiary also owns another company, 80% or more, then that company is also in that control group. So it can go down for various, lots of different levels. The second kind of control group is called a brother-sister control group. And that one's a little bit more complicated to identify because you're looking at 5 or fewer individuals, trusts, partnerships, who in the aggregate, when you look at all of them, own 80% or more of different organizations. But there's a second level, that the amount of ownership that each of them has in all of the different organizations, when you look at it the same amount, the minimum same amount, that it's 50% or more. So if Sam owns 25% of organization A and Sam owns 30% of organization B, for the second level, you only look at the 25%. So that's a little bit more complicated to figure out, especially because you have 5 or fewer more people that you're trying to identify. The next is an affiliated service group. And these rules are interesting. They came about, I think, mainly in the 1980s because of doctor groups. They would organize themselves so that the doctors would be in one control group and then the staff would be in a different control group. And the IRS said, that's not really fair. You guys are all working together to provide services to your patients. And so we're going to come up with some service and control kind of concepts that apply to you. And for example, if you work together to provide services to other people, or if one company is providing substantial management services to another company, then you're going to be in an affiliated service group. So the kinds of services that you have to provide in order to be an affiliated service group would be health, law, engineering, architecture, accounting, actuarial science, consulting, and insurance. So if you're in those kinds of businesses, you should start thinking about, well, am I working with other groups such that we have so much connection that we should be thinking about a control group connection there? And then there's lots of different combinations of those types of things.
So if I can interrupt for a second, Liz.
Sure.
When back in the day, when I was in-house, I found I expected to have time to do control group analyses and figure out how all this stuff works. But gave up very quickly and wanted shortcuts. So if I really don't care at all how a brother-sister control group is determined or a parent-subsidiary control group is determined, I just want the damn list, what do I do?
Well, there are a couple of things you can do. Hopefully, if you sponsor a tax-qualified retirement plan, you should have already identified your control group members for purposes of non-discrimination testing. That's, for example, your coverage testing that you need to do maybe every year, maybe once every 3 years, and you need to figure out who all of those people are. And if you have done a 5300, an IRS 5300 determination letter application, that's the application you send to the IRS to ask for approval that your 401k plan or your pension plan is tax qualified. There's actually a listing there of all of the your control group members that you're supposed to list. So that's one area that you can go to. The other is your tax people. Maybe you have been filing consolidated tax returns where all of your control group members are filing their taxes together. That would also be another potential area to go to and ask those people if they've identified your control groups. But if not, get started right away because it can be difficult.
Good, thanks. Stacy, at a company like Cargill, is it hard to figure out what your control group is?
Yes, I was just going to comment a little bit about, well, it's not that hard, but talking to your tax people, I think that was where I started, actually in the context of an IRS determination letter, and the list you'll get from your tax people is much larger than the list of entities that have employees. So I actually ended up having to work both with tax and payroll to identify not only all the different entities, but the entities that actually have employees is the other key part of it. So you need some multiple help in that
Good.
space.
Yeah, and that's a perfect example, I think, of how this is going to build new coalitions within a company. Because, control group is fundamental to, knowing your control group is fundamental to getting to these various ALE labels. But it's not the same. Would that be kind of, as Stacy pointed out, and you'll see a little more about this later, an entity that hits that control group list for purposes of the retirement plan filing that doesn't have any employees isn't an applicable large employer, okay? Or a member, okay? All right, Melinda.
Well, can I ask Stacy a question? Because, we obviously want to get this right, but what's the downside to you guys getting that wrong?
For ACA reporting? Well, I guess you're putting the wrong employer down. Well, part of it for us too is the penalty is based on is based on the member, right?
Right.
So, we're calculating our coverage percentages member by member. So you want to make sure you're reporting people under the right entity. so that your coverage numbers are all going to come out correctly. I guess I've never really thought about other implications other than just,
Yeah,
I mean-
that's the question. Like, I think it's critical for the small employers, I think, who might be under the 100 employee threshold or 50, to know that they're part of a control group that pulls them into the ACA.
sure,
I mean, that's
that
critical.
they have reporting
Yeah,
obligations.
exactly,
right,
exactly.
right.
But once you get over that threshold, everybody's going to
Right,
report.
all of our entities are going to. It wasn't a
Exactly.
matter of figuring out if one entity had to report or another, but I do think it's important for us to get it right as far as coverage percentages.
I want you to get it right.
Thanks. Me too.
But I just wanted to beg the question, you know, what
Yeah.
happens if we don't? And I guess I feel like, look, if all of your applicable large employers within your control group are reporting, and they're all covering the requisite percentage of full-time employees, it may not be the end of the world if you get it wrong. And I'm raising that as a possibility. I'm not necessarily advising that you should get it wrong.
No,
but-
I like that. I like that
Okay, all
point
right.
a lot, because I do think it's a lot harder to determine whether entities have employees than you might think it is, which sounds like a very elementary thing. Does that entity have employees? And it's just not known.
Good.
Again, I know that sounds ridiculous, but you say, well, who issues their paycheck? Or, you're just asking basic questions, but it's that's a good point in that maybe if we do our best efforts, that's my mantra, good faith effort, that if we get it wrong,
Yeah.
what does it really mean for a company like Cargill?
And I feel like this year, we've got 30% to play with. So
Right.
each of your ALE members has to be covering at least 70% of its full-time employees. You can't fail on that. Unless you have made a conscious decision to fail, you cannot fail on that, because you will be facing a significant penalty. So that's what you have to make sure they're doing, and we have the 30% cushion this year. So I think that's a significant benefit to us this year. Next year, it goes down to 5%. So it becomes a much, I think, scarier proposition. I see a question?
Yes, the thing that concerns me is that if you look at this from a total process standpoint, we're going to be giving a 1095 to an employee and a W-2 to an employee. That both of those forms are going to come together on their federal tax form 1040. They better have matching EINs.
Can you repeat the question, Laura?
Yeah, so the question was basically, look, our 1095Cs and our W-2s should have matching EINs. Absolutely agree. Absolutely, yeah. And is that a problem? I mean, apparently it's a bigger problem maybe than one would think.
Yeah.
Yes, this is what I'm saying. You could potentially create that problem if you had the wrong EIN on an employee's 1095. That could, that could cause a fracture in the integrity of the filing process for that individual.
Okay, great point, yeah. So ideally, our W-2 EIN and our 1095C EIN line up completely, and if they don't, it's gonna trigger a problem.
Yeah, okay, so remember, we're still at the control group kind of phase, and we're going to pass it on to Liz for the next slide, but let me just comment on something that Stacy said. You get this list of corporations as your control group, and it can be amazingly hard to figure out who is employed by which corporation. In the way that this should work for accurate reporting, it might not be justified by the facts, is that you look at you look at the EIN on the W-2 that's issued to that employee, and that's where they get their 1095C. And I think for webinar people, someone in the audience, the comment was, you're going to bump into some situations perhaps where you issue a 1095C that has a different EIN than that employee's W-2, and that's going to cause some problems. Okay, Liz, a few more tips on identifying control groups, please.
Sure. Well, I talked about some of these already, but I think that there are two other points that I want to make. One is for nonprofit organizations. They don't have stock per se, but what the Internal Revenue Service has told us is that you're supposed to look to see who has the authority and the ability to name the directors of a particular nonprofit organization. And if they can name 80% or more of those directors, then they are in your control group. So that's something to think about. If you're a government or church entity, there also aren't exact there's not an exact science to figure out if you're in a control group there. So you're supposed to be using a good faith interpretation. Sorry, that's what I've got for you. So anyway, we can talk, but there really isn't a very good, there really isn't a very scientific way of figuring out control groups for those types of entities.
We love good faith interpretations. Did you have a comment down there?
Yeah, I do want to reiterate how critical it is for the small employers to think about this issue because they could be pulled into ACA because of this.
Yeah.
And I would particularly echo the nonprofits. I think the nonprofits don't realize they could be in a control group with another nonprofit because of this board issue. And that's
Yeah,
all.
good point. Yeah, and I think Tim Goodman has some expertise in that. He's looked at that issue for some large nonprofit employers, and it can get a little tangly. Okay. Whoops. Oh, I asked Lori Wozniak to surprise me and throw this slide in the deck somewhere in the first third. Anyone watch Comedians in Cars Getting Coffee with Jerry Seinfeld? It's a great internet kind of thing. It's Honda sponsors it, and while he's interviewing, a comedian, Dave Letterman or whatever, Honda drives by, and that's the product placement. So our product placement here, I'm taking too much time on this perhaps, but we are as a group collectively at Dorsey doing some fixed fee arrangements for ACA reporting. And happy to chat with anyone about that because we think that many of you are going to be very well served by your vendors and consultants, and that occasionally it's good to have sort of a second check on things. Okay? Thanks, Lori, if you're listening. Okay. Wow. Now I got to focus here. Okay. Control groups. Okay. So we spent perhaps more time than you want talking about control groups, and nowhere in these forms do you see the term control group. But you have to know what the control group is to get to the alphabet soup, the ALE alphabet soup that shows up on these forms, okay? So a controlled group with 50 or more employees on a business day in 2014 is an aggregated ALE group. And you're going to see that term used on the 1094s and the 1095s, okay? So let me just say that one more time. Any control group with 50 or more employees on a business day in 2014 is an aggregated ALE group for 2015. Liz,
Yes,
I did this slide without Liz's approval or checking in on it, and I was a little sloppy.
Well, I just want to make sure that you all understand that it's not just an employee, it's your full-time employees with full-time equivalents factored in. So if you have, somebody who's working part-time, more than one person working part-time, you aggregate them. And that's an important thing to know. And also there's a special rule if you're a new employer. I don't know if we have any new employers in the group who are listening, but obviously if you're looking at a prior year and you're just first in business this year, you're not going to have a prior year to look for. In 2015, if you reasonably expect to employ, and you do employ an average of 50 or more full-time equivalents on a business day in 2015, then you are in an ALE group, aggregated ALE group.
Good. So, theoretically, and remember, remember the landscape here. We find the control group. If the control group has more than 50 employees, FTEs, it's subject to ACA, and it's subject to the reporting requirements. That's why we're going through this exercise, okay? Theoretically, it's possible to have a company with 200 part-time employees, and once you've done the math, conclude, I think anyway, that those 200 part-time employees turn into 65 FTEs, and you'd be subject to the reporting requirements.
I just wanted to point, and maybe you're getting to this later, but you mentioned that we've been talking about control groups, but nowhere on the form does it say control group. It talks about this aggregated ALE. I literally just had a call from the person managing this for us that had wanted to just verify for me that she could check no for all of the entities on aggregated group because we've never talked about that term. All we've said is each control group member.
Okay.
And so then I said, well, actually, it has to be yes for all of those, and then had to explain the control that it's basically the same thing as the control group.
That is a wonderful anecdote, and that's why we're taking the time to start out with control group and then morph into aggregated ALE group, okay? And what's an aggregated ALE group? Control group with more than 50 employees. There's a question.
Yeah, so I just want to confirm because your slide says checking back to 2014 for 2015. So since 2015 is the first year of the reporting, right? In 2016, Are we actually going to have to go back to 2014, or is this go to 2015?
Okay, so the question is timing, and I'm not super good on these rules because a lot of our clients are going to be well over the 50 limit. But the question goes to, you know, the slide here looks back to 2014 to determine if an existing entity, let's forget the startups, if an existing entity is a large employer for 2015. And that's how it works for 2015, and I'm quite certain that that's how it would work in 2016. We would look back to 2015 and count our employees. I'm looking for help with my panelists. I've got that right, don't I?
Right, yeah, so, yeah, you're gonna look to 2014 for purposes of deciding whether you're subject to ACA in 2015.
Yep, but then let's say we go to 2016. We look back to 2015. I'm looking at Tim Goodman, and he's nodding his head. Okay, thank you. I would look back to 2016 and do the math, excuse me, for my 2016 filing, which would be due in 2017. I would look back to 2015 to do the count, okay?
Right, so just remember, if we're filing, right now we're talking about a filing that we're gonna do in 2016, but it's really for purposes of 2015. So we care about what you are in 2015.
Good.
And I think, but do we have 100 for 2015 as opposed to 50? No?
There are some transition rules for employers who are between 50 and 100, and we're kind of beyond the scope of what we're going to talk about right now. Okay? Did we answer your question?
I think so.
Okay. For the webinar people, we think we answered the question. Okay? There's always going to be a look back year for this counting, is sort of the tweet, Jeff. Okay. All right. So an aggregated ALE group is a control group that is over the 50 employee count, looking back 1 year, okay? And the aggregated ALE group is subject to the employer mandate in 2015, subject to ACA reporting for 2015, due in 2016, and that is the entity, the identity of which is requested on the 1094. And take a look at, you know, the instructions for Forms 1094 and 1095C are actually really good. And they have a definitions section that you might want to sort of just print and set on your desk because it can be very handy.
Slide.
Switch the slide, Bob. Thank you.
So one thing I just wanted to add is that on the first bullet point, I think maybe Melinda just referenced that, is that there are some transition rules for this year. If you are between 50 and under 100 employees, you may not be subject to the penalty or tax portion if you haven't reduced your employee workforce or you haven't significantly decreased your coverage. But you still have to do the reporting. So I think that's kind of an important thing there, especially with the good faith efforts that we've been talking about.
Good. Okay, so I need to get to work while Liz is going to talk about this slide.
Oh, yes,
Do I have this right?
yes.
Okay. So I'm going to break our control group up into an aggregated ALE group, okay, with separate members. So these boxes represent the employees for a single control group. And we thought that we just needed to file one 1094C, okay? It's never that simple. Most big companies have employees at different entities, okay? So I'm going to sort of split up this control group into some ALE members. Take it away, Liz.
Okay, so I'm not entirely sure what I'm supposed to say when he's moving boxes.
Pretend I'm not here.
Okay. So here we are.
Very heavy.
We have a parent that has 3 employees, and if you would think about it, okay, I have 3 employees, nope, I don't have to file. Well, haha. You look down and you have a subsidiary that you own that has 376 employees. You have a wholly owned LLC with 50 employees. You have a division, part of the parent, that has 75 employees. Obviously, you're over the limit, so you're filing.
Okay, so that is our. So there's our aggregated ALE group. It's not so simple as one 1094 for one batch of employees. You need to break your control group up, your control group with more than 50 employees that's subject to ACA, into different members, each with its own EIN. each of those members with an EIN is going to file its own 1094C, okay? So that's why we have 4 separate boxes, or piles of boxes, and 4 separate clipboards. On each clipboard is a 1094C, okay?
And I think another thing to think about too is that oftentimes we think about labels on employees. Oh, they're just seasonal employees, or they're part-time employees. What we're really looking for are who are your common law employees, and that, as Stacy was saying, can be difficult. It can be difficult to find out who the employer is. It's also difficult to, who's the employee? Is it an independent contractor? Is it a leased employee? We really need to look into those kinds of concepts here. So, and you should already be doing that. I mean, the IRS is very worried about, tax reporting and making sure that people are getting the right W-2s, and whether or not your retirement plans are covering the right kinds, the right numbers and percentages of employees. So this is just another extension of why you should know who your employee is.
I guarantee you that some of you, the oh my God moment is going to come close to the end of the year, and you're going to have a batch of 100 employees somewhere, 100 workers, let's call them, and you're not going to have any idea whether they're your common law employees or not. So especially employers that have heavy contingents of leased employees, temporary employees, things like that, get to it. And those of you in the benefits groups are going to be the keepers of the wisdom on that more than anyone else, I assure you. Okay? Okay, so we have control group. Then we have aggregated ALE group, okay? So the control group is the control group with just your tax people. The aggregated ALE group is a controlled group that has more than 50 employees, okay? And then each separate member in that aggregated ALE group is an ALE member, okay? These definitions are in the instructions, and shortly after this seminar today, hopefully today, Liz Deckman and I are going to have a little webcast on these terms on our blog, dorseyarissa.com, that will review what we're talking about here. Okay, write that down, dorseyarissa.com. Okay, okay. So what we're going to do. So the significance of identifying the ALE member is that each ALE member has its own 1094C filing obligation, okay? So in this case, the boxes in front of the room here, and there's a slide that comes up in a second that shows these boxes. Each stack there has to file its own 1094C. Each stack has an EIN, okay? And you're gonna find like little, skunk work corporate entities that have been put together to research the next big thing, that have employees that are getting pay from the EIN for that entity, and you're going to want people to squish those individuals into one of these ALE member groups. Well, then you're going to have the problem that the participant in the audience here mentioned a few minutes ago with an EIN on a 1095 that doesn't match the EIN on the W-2. So now I'm going to go to the next slide, and we are going to run short on time, I know, but this is important stuff. So I think we're going to, let's see, I've been really bad here. We're going to do a quick quiz. Liz, do you want to set this one up?
Sure. Actually, I think, could we just, I know we're running short, but could we go back to the slide right before?
Yes, ma'am.
Because
sorry.
I think that the second bullet point there is important.
Oh, yeah, thank you.
Because as Bob has been saying, each ALE member is responsible for filing a 1094C. It may be that you file more than one 1094C because you're a big employer, you have separate divisions, you have different health plans that are covering different people. And in that case, you can file separate 1094Cs, but you have to file one authoritative form. And we'll show you that on the form a little bit later, but that's an important thing to do. So, to exercise your mind a little bit, we're going to have a test. If you look at the next slide, can you tell us
Slide, please. There we go.
who the ALE members are in this particular diagram?
So 30 seconds. Talk to a neighbor, preferably one you don't know, and see if you can figure out who the ALE members are in this group. Do we have anyone willing to venture, give us an answer? Or should we have Liz talk us through it?
Okay.
Oh,
I saw a
Courtney?
hand, I saw a hand.
Yeah.
Division A is a part of parent, so that's one.
Okay.
Correct.
Liz, you repeat so the webinar people can hear.
Yes, so Division A is part of parent, and so they're together, correct?
You have a wholly owned LLC, that's another. You have a subsidiary with the 376 employees, and you wouldn't need to file for a subsidiary with no employees.
Perfect. So, so the parent, the wholly owned LLC, the subsidiary with 376 employees, those are the filers. The subsidiary with no employees doesn't need to file. There's nobody to file for. And Division A files with the parent. Perfect.
Good. Now, there's always room to muck. I mean, Division A might have an EIN. And if it does,
good point.
then it's an ALE member, and it has to file a 1094C. You know, the corporate speak doesn't always match EIN speak. So what you really want to do is look at your EINs and use that as a starting point to figure out who your ALE members are. Okay? And as Liz mentioned, that subsidiary, and Courtney, with no employees doesn't have to file. However, if you have a subsidiary with, you know, just a few employees like the parent, you got to file. Okay. There's the graphic for the webinar people. This is the hard work that I did on our boxes that shows you that we take an aggregated ALE group, which, remember, control group with 50 or more employees. We divide it into EINs. Each EIN has at least one U.S. employee, and that's how we figure out where we file or how many 1094Cs we file. Okay?
You mentioned U.S. employees. I just would throw in, too, that another question I've gotten is what about our inpats or people that are working in international places? I believe this is correct, but my position on this has been that if they're not employed by a U.S. entity, then you don't have a reporting obligation for them because the reporting obligation is on the employer, and their employer is the foreign entity for certain groups of the INPATs. So that's one way you can deal with those folks. If you have U.S.-based people, though, that are employed by your U.S. entity but are positioned internationally at the moment, they're going to fall under your U.S. entity reporting obligation.
Thank you. And let me just say, Laura Lynn, thank you so much for tweeting your question to us on FTEs. We're not going to get to it right now, but we'll talk to you after the seminar. Also, on some of these more specific questions, we're going to try to, in the next week, get some content up on our blog that answers some of them to the extent we can. Okay. Let's see. We're going to skip the 1094C applied learning. What we're going to do here is go through the form and kind of talk you through what we've just learned, but I really think we're going to run out of time. Let me just say that the dreaded line 22 is in my opinion, a train wreck. This is 1094C that asks 4 questions that are sort of apples and oranges, and it's why I totally always hated multiple choice tests, because you can check one or more boxes, all that apply. We'll try to put some narratives brief up on our blog about how those boxes work with each other and when you might check one and how if you check one you can't check others. There's the heavy lifting on 1094C, Part 3. That's basically where you say whether you're in compliance or not. And you know, if you're reading the 1094C instructions for, boy, the glass thing as you get older is so hard. Let's see, the minimum essential coverage offer indicator, you wanna check yes, but the first paragraph of the instructions for that thing are gonna stop your heart, because they only describe the 95% coverage rule, and if you don't satisfy that, you're screwed. But as you keep reading, you see that especially for 2015, you've got the 70% coverage rule and the likes, okay? Let's see. There's the list of your ALE members, okay, of the aggregated ALE group. And what's the foundation for determining all that? Your control group, okay? All right. Cleanse the palate, okay? This is from healthyeatingsfgate.com. Crackers, lemon sorbet, pickled ginger, and milk. I wish we had pickled ginger to pass out now and just take a little break, because we're going to really, really shift gears from Form 1094C, the big one, to 1095s, okay? And Melinda and Holly are going to walk us through the 1095s.
Okay, thanks, Bob. I'll start. And Holly is really the heavy lifter here. She's going to go through all the examples, thankfully for me and you. But let me just give a little background here. So we've talked about the fact that this form is a lot like the W-2, and that's true. And in fact, we've also stated that you need to have the same EIN. That's very important on this as you do for your W-2s. 1095C should have the same EIN. There are a couple distinctions between the two forms, however. One is W-2s go to everyone you pay, everyone on your payroll. 1095Cs won't necessarily go to everyone on your payroll. Your obligation is to your full-time employees, also to those to whom you are offering, those who are covered under your plan will also get a 1095C. So you won't necessarily be sending a 1095C to everyone who's getting a W-2. The other distinction I would make, and maybe I'm underestimating the W-2s, I mean, they've been around for so long, we seem to have that down pretty well, all of the payroll services. These 1095Cs collect a lot of data from a lot of different sources and seem very complicated to me and requiring a lot more data feeds than the W-2 does. And I may be minimizing the W-2, but I think we're quite used to the W-2s, and this obviously is a lot more complex at this stage. 1095Cs, remember what they're doing. They're establishing that you're meeting your mandate. They're also establishing that someone is meeting his or her individual mandate. They also may be establishing that somebody is disqualified from a subsidy. So there's really those three things that they're doing that we kind of touch on in that second bullet on this slide. And you'll file the 1095Cs with the IRS, and you will also, similar to the W-2s, be sending them out to the employees. The deadlines are essentially, or basically the same as the W-2s. We have heard suggestions that if we are going to get some relief, this may be a place we would get relief, that they may delay those deadlines. I would suggest that not to rely on that, but that would be my hope. So I'm going to go to the next slide now. One thing to keep in mind as you're looking at the 1095C is you need to know how you are identifying your full-time employees. Are you using the monthly measurement method, or are you using the look-back measurement method? That's important for a couple of reasons. For example, changes in status are treated significantly different if you are using monthly measurement and look-back measurement. And Holly has a lovely example of that, so we'll get into that later. So make sure you know whether you're in the monthly measurement method or the look-back measurement method. And I think by now most employers know which method they're using. Limited non-assessment periods. Again, here's a distinction. If you're using monthly measurement, I would say to you, a limited non-assessment period, which we're going to talk about in a minute, is usually a waiting period or any sort of delay between your date of hire and your coverage effective date. So very common to have coverage start first of the month following date of hire. That would be considered a limited non-assessment period in the monthly measurement method. Also, a waiting period is fairly common, first of the month following 60 days. We will let you into our plan. Again, that's when that's considered a limited non-assessment period, which we'll talk about in a minute in the examples. When you're using the look-back measurement period, a limited non-assessment period is largely your measurement periods. So you may be applying a measurement period to someone, which means you are keeping them out for up to a year. That is considered a limited non-assessment period, and we'll talk about that in a minute. There are a couple other nuances to limited non-assessment periods, but those are kind of the big limited non-assessment periods that will apply. Multi-employer interim rule relief. So if you are an employer with a union and your employees get their coverage through the union plan, it's a highly complex reporting at this point. and come talk to me later after. I'd be happy to talk to you about that. We apparently don't have enough time to go into that very much. Suffice it to say that you're going to struggle with lines 14 and 16 in particular on these forms. And lines 14, 15, and 16 are what we're really going to touch on here as Holly moves through the slides. And so I'm going to turn it over to Holly to tell you a little bit about lines 14, 15, and 16, and then to walk through the examples.
If I can jump in just for 1 second, you know, I would recommend highly to those of you in companies to, you know, pause for a moment in the action here and try to maybe put together some bullet points or something that describes, you know, your use of the monthly or the look-back measurement period that you have handy that you can pull out when you're having a conversation with a vendor or even someone else in your company. Because I mean, I've seen this happen a lot of times where, you know, we get straight down into line 14, 15, 16, and we start talking and throwing out all sorts of terms. And I've seen, you know, hour-long conversations where both people think they know what each other is saying, and by the time you're done, it turns out that they had no idea. So a little attention to these terms and labels up front at the beginning of conversations can save a lot of headache as you move along. Holly.
Well, thank you. And as we're going through these examples, especially members of the panel, if there are questions or if there are things that you'd like to point out, please feel free to jump right in. I think before we even start the examples, when we're dealing with lines 14, 15, and 16, I think it's best to think about exactly what we're telling the IRS when we're using these codes. Line 14 describes the type of coverage that's being offered to the employee. It especially goes to whether or not the employee, spouses, dependents are being offered that minimum value coverage. So 14 is what's being offered. Line 15, when you're not making a qualifying offer, which has a specific premium level, which does not exceed 9.5% of the mainland federal poverty line, this shows the employee-only premium for that month and goes to demonstrate whether or not that monthly premium is affordable. Now, you're going to be reporting in this line 15 the employee-only monthly premium, regardless of whether or not they have their spouse enrolled, regardless of whether or not they have their family enrolled, because affordability goes to that employee's coverage. Line 16, I like to call the exceptions line. This is that line where you get to tell the IRS, okay, here is what we are doing. Here is what is happening, and here are the reasons why we wouldn't, shouldn't, or couldn't be assessed a penalty under 4980H. So those are kind of some background thoughts to think about as we go into the different examples.
No, you go, Linda.
Yeah, I'd just point out there's a handout which has your Series 1 and Series 2 codes. And so you'll see the Series 1 codes are the codes you're going to use on line 14, and the Series 2 codes are the codes on line 16. So that's kind of a handy reference to look at as we're walking through.
Yeah, and we're going to put that up on the blog as well. Those, you know, distilling those codes down and having them handy can be really useful. And the instructions get a little wordy, so it's good to have the summary. And just one thing I heard from one of these major vendors this morning was, you know, that 16. Line 16 is where the IRS is going to look to decide on penalties. You know, I mean, they've got to look at the 1094C, obviously, but a lot is riding on line 16, according to this person. Holly.
All right. I think we've got one question.
Just a clarifying question. On line 15, if I'm not using a qualifying offer, the cost I'm putting there is the lowest cost option that I'm offering the employee, not necessarily what they're enrolled in, correct?
Okay, repeat the question, Holly.
Yes, the question is that on line 15, if we're not doing a qualifying offer, the premium that is reported is the lowest, it's the lowest employee premium, employee-only premium that is being offered to employees, whether or not they're even enrolled in that option. So for example, under a health plan, the employer can have many different options at different prices. But this is the lowest cost employee-only premium that would be available. And yes, that's correct. On this first example, we're going to look at reporting an ongoing full-time employee. This is one of the simpler examples, so we figured we would start with this one. An employee and a spouse are enrolled in minimum value self-insured plan all year long. They add a child in July of the year. The value of the self-only minimum value premium is $110 a month. So when you start looking at the codes, you're going to see that since they were enrolled all 12 months, you're going to have code 1E, which is the minimum value coverage offered to employee and at least MEC to spouse and dependents. You're going to have that $110. And then you're going to have code 2C in line 16. 2C is the trump code. It goes over any other code in line 16. If your employee is enrolled in coverage, you're going to be using 2C.
What's 1A? Why would you use 1E over 1A on the line 14?
And that's an excellent question.
Oh, because it's 110 a month.
Okay, so we're looking at line 1A.
Sorry, I just
on line,
answered
no, this is good. Why
This
would
is
we
an
use
excellent
1A
question.
on line 14?
Well, the reason being is that, as Melinda and I were talking earlier, Melinda made a great point about saying that 1A is kind of the gold standard of offers that you can make to your employees. 1A is a qualifying offer, and this is a defined term, that your employee is offered minimum value coverage that costs less than 9.5% of the mainland federal poverty line, which is approximately $93.18 a month, and that in addition to this coverage, you're also offering at least minimum essential coverage to their spouse and dependents. So this is that one code that you can put in and say, yes, I am checking off all of these boxes. It's MEC, it's minimum value, it's affordable, and it's going to everybody. I also tend to like 1E as well, and the reason being is that it's almost as good as 1A, but you're going to have to demonstrate that it's affordable. And that's where where you start reporting the value of the premiums in line 15.
So if you do 1A, do you have to do line 15 and 16?
And no, if you do 1A, you are exempt from doing line 15, but you are still going to have to report in line 16.
Melinda, were you going to add something?
Nope, that's
Okay. We clearly need a board game or something. Yes. Okay, Holly, keep going.
So as you're able to see in here, because they were covered all 12 months, everything can be recorded in that first column, which is always a nice shortcut. Down in part 3, what you can see is in these boxes, you can see each month that individuals are covered. So in column D, you can see that employee and spouse were covered all 12 months. And then in line 19, where you see child, you're going to start seeing that the child is covered starting in the month of July and through the rest of the year.
Okay, so remember, we are deep in the weeds now, and a lot of you aren't going to be making these individual calls. You're going to get the hard questions, okay? But I don't think you can answer the hard questions unless you have some understanding of sort of how the basics work on these forms. So we've figured out, you know, who's filing what forms, and that we're subject to ACA, and now we're into the granular, we're into the nitty-gritty details of what we say for each employee for whom we report. And I see a question.
Bob, real quick, just nitty-gritty details generic, but so Social Security numbers, I get it, they didn't have them for baby yet. Are we going to be required to get Social Security numbers for everybody? And how do you know whether a child has one or not?
This is a wonderful setup that Stacy should start with.
Well, I don't know. The baby is a
Oh,
unique.
excuse me, and for webinar, the question is, how do we get these Social Security numbers for that bottom part of the form 1094? 1095.
I think the babies are a unique situation, right? Because they don't have them. I think you have some time. I haven't looked at that specifically, but the obligation now is to request the Social Security number of the dependents, and there's an entire process. Is it in the regs? I don't know if it's in the regs or in the instructions or where it is, but in the regulations, it gives you a very detailed description of how you need to ask for the Social Security numbers of the dependents, and if you do that, then you're deemed to have met the requirement of reporting the Social Security number even if you don't have it. Now, frankly, I don't know when that kicks in for a baby. If that, I know it's an annual process that you have to do. I would have to look more closely to see how often. But it's raised a couple of questions internally, just to sort of aside to a different issue slightly, is, you know, the question has come up, you know, can you mandate then that people give you their social security numbers to enroll in the coverage because you supposedly need them now for reporting? And I think where we've come down with some discussions with Melinda and Bob is that's still not an acceptable method of, you can't force people to give you the socials because ACA doesn't really mandate you have it, it just mandates that you ask for it. And so if vendors are telling you they have to have it for ACA reporting, that's technically not correct. They don't have to have it. We have to ask for it is really the mandate. And maybe by only requiring we ask for it, there's an implication there that you can't mandate it for people to get into coverage. So that was actually a discussion we had to have internally. I don't.
I think you just, you do use the date of birth if you cannot get the social, I believe. So that's the indicator that you didn't get the social.
Yeah, the question was, is there a code that says you didn't get the social? And the answer is that date of birth is essentially what you do.
I think that's right. Yeah, there was a question here.
Yeah, again, it's important to keep focused on where this form is going. They're not really saying no to the employer, they're saying ultimately no to the IRS by not giving them that information. So again, you're gonna be matching up information. It won't always be consistent because there'll be some folks like dependents, 22 or 23 years old that aren't tax dependents, and they're not gonna be every 1040, but some of the dependents may be. The point really is that you want these dependent social security numbers because it can avoid potential assessments being made against you if the IRS
Sure.
can easily cross-check.
Yeah, so the point is it's in the individual's best interest to have those social security numbers show up on the form because that saves them some grief with the IRS. The tension that we're going to have is, you know,
It's a
if
privacy issue.
Cargill is going out to people and saying, you know, would you please give us social security numbers that we don't have? Trust us, it'll be all okay. You know, that's the tension that employers are having, I think. Melinda?
Well, and that's
Right.
actually what raised the issue for us, is employees were saying, I don't want to give you my dependent social security number. And so we had to kind of revert back and say, well, can we make them? And I think the answer was, well, no, because technically we don't need them for any reason. So we don't want to have that data if we don't technically need it. I think.
Exactly. Let me just, quick, another product placement, not really, but I have to announce the New York CLE code one more time. XQK821. There you go. Okay. Holly, did you want to go to the next slide or?
Or do I not get to say something?
I'm sorry.
Okay.
Talk.
I just want to, I think that's an excellent point about the socials. Really, the benefit inures to the employee and his or her dependents. So you could, I guess if you're going out and requesting it, you could make that as a marketing point. You know, we're doing this for you.
Right.
Yeah, I hadn't thought.
Because you could have you could have a penalty assessed otherwise, potentially.
Because they won't be able to tie the forms up.
Exactly,
Right.
yeah.
Yep.
Are we next slide, Holly?
I think we're next slide. All right, now this next slide shows an example of how to report a newly hired full-time employee. So with the fact pattern we have here, the employee is hired on March 15th, is subject to a waiting period of 60 days, so is eligible on the first of the month after the first 60 days of employment. And a qualifying offer is made on June 1st. So bringing in the discussion about qualifying offers from previously here. So this slide is specifically intended to show how a waiting period is applied. When you look at line 14, you are going to see from months January through May that code 1H is used because there has been no offer of coverage to the employee. Code 1A is used from June through December, indicating that a qualifying offer was made. Line 15, we can leave blank. Line 16 is where you understand how the employee is being treated with respect to these offers of coverage. So for January and February, we use codes 2A because he's not yet an employee. March, April, and May is that code 2D for a limited non-assessment period. So in this situation, the limited non-assessment period is that waiting period from the point in time he is hired until the point in time coverage is offered. And then this example assumes that coverage is accepted starting June 1st, and the code 2C is used through the rest of the year.
Good. So this is, yet another example of why sort of a cheat sheet on how your rules work to get individuals into the plan delivered to your HRIS people or your payroll people can save a lot of grief down the road. Next slide.
Next slide.
All right.
All right, the next page, as the heading is still the examples, but the bullet point says newly hired variable hour employee. So this is for all of those employers who are using a look-back measurement method to count hours for their employees. To simplify the example, we're going to assume that the employer is using a 12-month measurement period and a 12-month stability period, and they're not putting in place an administrative period. In this situation, the initial measurement period for this employee who's hired on March 15th, their year-long initial measurement period is going to run from March 15th of 2015 through March 14th of 2016. What's going to happen is that for the entire year of 2015, this employee being variable hour is still going to be in an initial measurement period, but is never really going to have an offer of coverage because we don't really know if he's full-time or not yet. So on this one, there is no Form 1095-C for 2015. Please note, though, that this employee is still going to be a part of the total employee count that is reported on your Form 1094-C Part 3 and Column C. He's just not going to be getting a Form 1095-C in the 2015 year.
So this is an example where that employee is going to be getting a W-2, but they won't be receiving a 1095-C.
Exactly.
Thus, they're close, but they ain't quite the same.
Here's a question.
Yes. So what if during several months of 2015 that employee works 130 hours a month or, 200 hours a month? So
Repeat the question too. Yeah, come on in, Lynn.
So what happens after a period of several months? So once you get through that measurement period, they average 130 hours a month, or on average at least 30 hours a week. How do they eventually get reported? And yes, that's an excellent question. They do. And if we advance to the next slide.
But I think during the first measurement period, regardless of the hours they work, you wouldn't report them because they're still in the initial measurement.
Right.
That's
Hang on, wait a sec. Let's give you a mic so that we don't have to repeat.
And basically, if, for example, in 2015, no matter how many hours they work, they could be working more than full-time, they could be working less than part-time. If at any point in time that year they're still in that initial measurement period and they haven't completed it, you're not going to have a 1095. It's once you get to the end of the measurement period that you're going to take a look and determine whether or not they have enough hours to be considered full-time, and then determine whether an offer of coverage is made. And then the reporting will trigger once it's determined that they've worked enough hours to be considered full-time, at least for that year.
But it's important to remember, this is somebody using the look-back measurement method.
Thank you. Yeah.
So if you were using monthly and someone worked more than 130, yes, you have an issue and you have a reporting obligation for that month.
Okay, Holly, back to you.
Okay, so on the next slide, we're going to get to the end of the measurement period. And that's going to be in March of the year. Let's see.
Am I on the right slide?
Go back to one previously. It's the newly hired variable hour employee continued.
How am I? Take a look. Is that right?
Excellent.
Okay.
This is the employee, you get through the entire measurement period and you find out the employee works an average of 32 hours per week during that year. So what's going to happen is that this employee has been determined to have worked enough to receive an offer of coverage for the entire stability period. In this example, we don't have a waiting period, and the employee is eligible the first of the month following the end of their measurement period. So for 2016, the Form 1095-C should look something like this. The employee, for the first couple months of the year, January, February, March, is going to have 2D coded. Now, in this case, 2D doesn't represent a waiting period. 2D represents the end of that initial measurement period. Starting in April, Code 2C shows that the employee accepted the offer of coverage. And as you can see further up in lines 14, it reflects that for the first 3 months of the year, there was no offer of coverage. And then starting in April, 1E indicates that they were offered coverage. Again, we're reporting $110 a month as being the lowest cost employee-only premium available to the employees for purposes of affordability. But this example goes to show that just because an employee who is a variable hour employee is going through a measurement period doesn't necessarily mean they're not ever going to get a 1095-C.
Is there a reason you use 1H instead of 1G during the measurement period? Because 1H is reflecting no offer of coverage to a full-time employee. But during the measurement period, you're sort of trying to sort out whether they're a full-time employee. Do the instructions say use that code for the measurement period?
That is an excellent question as well. I think, and Melinda, correct me if I'm wrong here.
So let's just focus for a sec. Where we are is upper left-hand corner. We're looking at those 1H's on line 14, and Stacy's comment was, could you do 1G?
Right.
And 1G, Stacy, remind us, is?
Part-time employee
Okay.
or non-employee.
Yeah, so why do you do 1H
But it,
rather
then
than
it does say
1G?
covered. It says covered under a self-funded plan, so maybe that's why you're not doing it, because they're not covered. Keep answering my own question, sorry.
But actually, that goes to illustrate, I think, the heart of the matter here and why we're spending a lot of time on lines 14, 15, and 16 is that these are really complex coding issues. And every time you go through them and you think you've gotten them correct, you need to go through them again just to make sure that that they're being coded correctly.
Yeah, and guess what? The truth doesn't exist. I mean, we're truly, I mean, you might have, Equifax saying one thing and ADP saying another thing and Xerox saying another thing for that little conversation we just had, 1H or 1G. And the important point, especially early on here, is to have a reason for why you're using it and use it consistently, I think. Would you guys agree?
Yeah, and I think you're telling a story. I think you want to make
Me?
sure. Well, yeah, you're always. But the form is actually a way to tell your story to the IRS. So I think what you're trying to do is make sure you're accurately reflecting what's going on, so that you're going to avoid a penalty. Your employee is going to be able to meet his or her mandate and or be disqualified from a subsidy if that's what should happen. So I think you want to keep those overarching goals in mind. And when you look at it from that lens, I think the coding in this example makes sense.
I think it's just confusing.
Yeah.
Because it says full-time employee, but I think the whole point of the measurement period is you're trying to determine whether
No, it's an
they're
excellent point.
full-time.
I just think, I'm not sure there's a better fit.
No, I don't think so either. I
Yeah.
didn't mean to put you guys
No.
on the spot.
No,
It's
that's
just-
good.
That was,
I think in the instructions, 1G can only be used in the 12-month block, that you're not supposed to use it month by month.
Okay, someone in the audience is saying that the instructions might answer this 1H, 1G. And let's keep moving. Let's not go, and we do have one more question.
Well, I was just gonna comment, in this case.
Hang on a sec. Is the mic on? Okay, go ahead.
In this case, you measured and you did determine that this individual was a full-time employee, otherwise there would have been no offer of coverage later.
Yes, in this case, we determined that they were working enough hours that even though they have a variable schedule, they are working enough hours to have the ability to be eligible on the same basis as a full-time employee.
And that might support the 1H, yeah.
And that would support the 1H. I think the other thing as well is that 1G is where you can actually say that that individual is part-time. You know for a fact they're part-time. It's interesting that they don't have a code in that line 14 to indicate that somebody's a variable hour employee.
1G does say, enter code 1G in the all 12 months box and do not complete the monthly boxes, so Sue is right.
Okay, okay.
Good job, Sue.
Go ahead, you had one other question?
So if you're only reporting full-time employees, when would you ever use 1G?
When you provide coverage, say, to your part-time employees, for example, yeah. Or you're providing coverage to like a board member. Yep, a mid-year status change maybe, but.
And remember that 1095 isn't just about satisfying the employer mandate. It's about reporting to the IRS offers of coverage as well as offers of coverage, okay? So some of what pops up on 1095 isn't really about the employer mandate, it's about the individual subsidy. Okay, where should we be on slides, Holly?
Or really in the individual mandate. So if
Thank
you're
you.
providing coverage to a part-time employee, they need to be able to, they have to show that. So that's what you're doing here too.
Good. Holly, where do we want to be on slides?
All right, I think we can move on to the next slide. And this is the terminated employee. And we're going to have to unpack this example a little bit, and I apologize for its complexity. But part of the reason for this example is to show how you're reporting a full-time employee who really hasn't accepted your offer of coverage, and what happens, how you report them when that employee terminates employment. So when you look at line 14, you can see that they were offered coverage through, and this is one place I would like to point out. Please take your pens and write 1E in the month of August. Again, this is an example of the complexity of these forms. Instead of 1H, please, in the month of August, line 14, that should be 1E.
Tell us why.
And that is because the employment terminated on August 15th. And the use of the code 1E for an offer can still be used even if the employee terminates coverage for the month but would have otherwise still been eligible for coverage.
Oh my.
So that would only apply if your coverage continues through the end of the month.
Actually, it would have, except for the termination. And let me see here.
So if your plan cuts coverage off date of term, do you enter 1H then?
No, it's 1E, right? Didn't we conclude? So if you're terminating coverage mid-month due to termination of employment, but they would have had coverage had they remained employed
okay,
through the end of the
okay.
month, I think you get to use 1E.
1E?
Yeah.
Okay.
Okay. Keep going, Holly.
All right. Now below, why are we using codes 2F? We haven't really looked at this one yet before. And if you've noticed that code 2F is in there from January through July. Code 2F indicates to the IRS that your offer of coverage satisfies one of the affordability safe harbors, specifically the W-2 safe harbor. Well, why are we indicating that? Why is that important? This is because your employee has declined your health insurance coverage. They can go and get health insurance elsewhere, whether it's through their spouse, they can go to an exchange. But by telling the IRS that your coverage satisfies the W-2 safe harbor, this indicates that that individual is not eligible for a premium tax subsidy when they go to the exchange to receive coverage, which means the employer is not going to be liable for a penalty just because this employee decided to go to the exchange and apply for coverage.
And remember, even though the 1095 is a lot about the individual, remember the comment from the payroll vendor, line 16 has a lot to do with whether the employer might owe a penalty. And the description that Holly's giving right now is sort of how the IRS might look at line 16 and make a call as to whether there's a penalty assessable for that individual's lack of coverage or not.
Excellent. And even further, to keep going right down the line, for the month of August, there is a code 2B that signals that the employee, although he was not covered through the end of the month, that the employee could have been had they remained employed, so there's no penalty there as well, but it indicates that the employee terminated during that month. And then 2A for the rest of the year when they're no longer an employee.
Okay, this should be a simple employee termination.
Yes.
And that's why, I think it's important for those of us in this soup to get the basic ones down first, because if you try to start talking about the disabled COBRA participant with, a couple spouses, you cannot, and we've had that, you cannot get it right, you just can't, okay? So next slide, Holly.
And speaking of COBRA, terminating employee elects COBRA coverage. However, there's one spouse in this example. Keeping it simple. I would like to let everybody know, though, that the IRS issued questions and answers regarding the Affordable Care Act reporting and how to work with the forms. Specifically, the guidance that was issued at the end of May gives examples, very detailed examples about how to work through COBRA offers, COBRA acceptances, and who is actually accepting it and why, and how to code it. So if you're looking for those kinds of instructions in the instructions to the forms that we have right now, they're not going to be in there. So the IRS questions and answers do help significantly with how to report COBRA. That said, I have been through these questions and answers several times, multiple times. I still do not understand the reasoning for why the IRS chose the coding that it did. But leaving that out, we can just kind of follow what they instruct, and I think that's the best that everybody can do. So in this example, you have an employee enrolled in family coverage, self-only premium, $110 a month. The employee terminates employment on July 20th, and the plan offers coverage through the date of termination. COBRA is offered and accepted for the family, and the single-only COBRA premium, lowest cost, is $300 a month. So when you take a look at this example, first of all, you're going to notice 1E across the top, that coverage has been offered to the employee, the spouse, the dependents. Line 16, when you see codes 2C, from January through June, you can see that the employee is enrolled. When you take a look at July through December, you also have 2C. What's the deal? Again, it's the fact that since the employee has enrolled, even though they're not still an active employee, that code 2C trumps any other codes that are available in that line 16. Where you're going to see the difference is that starting in July, the premiums that are reported for COBRA coverage are going to go up from $110 to $300.
Good. Just a quick couple side points. Anyone wanting CLE or HR credit, sign the green sheets before you leave. And thank you very much to Lori Wasmick for all the help she's given us today. And this seminar will be on Dorsey.com, hopefully on DorseyErisa.com for playback after we're done. And question in the back.
Hi, I have a question on a terminated employee. COBRA coverage is typically 24 months or longer if the employer lets it, but what if the employee in this example terminated in 2014, continued dependent coverage, and we're thinking of this as a way the employee demonstrates individual mandate compliance?
Yeah, that's exactly right. So what you're saying is basically you're just going to start your reporting in 2015, and they're clearly no longer an employee, and they were never employed by you in 2015. Yeah, you still have to report for them just exactly as you identify. I should have repeated the question. So the question was...
That was on the mic.
Oh, okay. So that individual can demonstrate that they've met the individual mandate. So you can report them either on the 1095C or the 1095B. I think a lot of employers are opting to go ahead and report them on the 1095C. However, it would be a slightly abbreviated reporting, I believe, or would it look, or is going to look, at least you're going to convey that this is not your full-time employee. So you're going to use the code, I think that we talked about that basically you've offered coverage to someone who is not your full-time employee. That's the code you're gonna
That's-
use? Is that the code we
Well,
talked
that's
about before?
G, part-time employee or non-employee.
Yeah, yeah. So you'll code them that way, and then talk about the offer of coverage aspects.
Let's take one more question from the audience. Laura, can you get the mic up there? Hang on one second, grab the mic. We got about 6 minutes left by my clock here. Talk in 140 characters or less.
There's an assessment process that I'm struggling for the reference that would be able to allow the IRS to differentiate which part of this year is potentially assessable as a penalty, okay, for affordability, for example. Obviously, when the COBRA continuing, there would be a process that would go back assessing the employer, and the employer would report that that person terminated employment on such date. What's the name of that process, and do you know the applicable form that? I read about that recently, but it's not, it didn't stick.
You stumped us for the moment, but we'll take a look at it.
Okay.
Okay? Holly, you got time for one more slide. What's your favorite slide that you dying to cover?
Oh, my goodness. Well, how about we go with one that's possibly along those lines of what to do when you have a non-employee who continues on COBRA coverage. This was one of the examples that the IRS had done. So this is the last example in the deck. We will leave the reduction in hours examples for you to ponder in your spare time. They are definitely fun and enjoyable, but I think this one is always relevant, considering that employees do unfortunately get divorced, and sometimes their spouses will enroll in coverage. So, oh, Bob, will you back it up just one, please?
Is that right?
That's perfect.
Okay.
So in this one, you have the employee and spouse who have a divorce on May 15th. Now, going back to that rule, one employee from one employer is going to get one 1095-C. So the employee who has been covered all 12 months of the year is going to have their 1095-C. Notice in Part 3, the spouse is going to be covered only for those months that they are married. On the next page, when you have the spouse that is receiving benefits as a COBRA beneficiary, they're going to receive a separate Form 1095-C. In this particular situation, the IRS says to use code 1G for each of those months that they are a COBRA beneficiary. You're not going to have to report anything on line 15, because affordability does not go to spouses, dependents that are on COBRA coverage. And you're not going to report anything on line 16 because the employer isn't going to be subject to a non-employee who goes to the exchange and receives a subsidy.
Nice. All right, we have 3 minutes left and one question. Laura, are you still here with the mic? And to the extent you can keep this one neat and tidy, do it. Go.
So why doesn't May have a checkbox on either one?
Excellent. May should have a checkbox on the first one, because when it comes to Part 3, the interesting thing is that if there is any day, and thank you for your eagle eyes, I appreciate it.
That's good.
If there is coverage that is offered and coverage accepted for any day of the month, you're going to get a check on Part 3 for covered individuals. And for reporting that coverage has occurred in Part 2, they have to be covered through the entire month. So you've got two different timing rules that apply, whether it is in Part 2 where you're talking about the entire month or not at all, or Part 3 where even if it's just one day, June 30th. So thank you very much for that.
Okay, and don't be hard on yourself after this is over for missing a checkbox. Trust me. Okay, couple quick ending points. We're gonna put, if you're a headline reader like I am, not a bad way to learn some of this stuff is look at it in small doses. So you know, if you, I think kids don't use Twitter much, but if you're like 20-something kid or friend, can show you how to create a Twitter account. Put one up and follow us, because you're going to see a lot of little pithy one-liners that will help you to sort of digest how the ACA reporting works. We're going to put some more content up on our blog afterwards, as I mentioned. And just the very big picture, you know, figure out your workflow here, figure out your control group, which gets to your aggregated ALE group, which gets to your 1094 reporting obligations. When you got that done, go deep, 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 deep into the weeds and work on lines 14, 15, and 16. Work like there's no extension on the deadline and hope that there will be one. And thank you all very much for your time and patience here. And to our panelists.